Good morning, everyone. We're here today for oral arguments. We are going to begin with Appeal 25-1120, GT et al. Versus Samsung Electronics America Incorporated et al. And we'll begin with oral argument from Mr. Sostrin.
Good morning, and may it please the court. The plaintiffs in this case have alleged that Samsung is gathering their biometrics without their consent whenever someone takes their photograph on a Samsung device. And that is because when someone takes a photograph on a Samsung device, Samsung, through its gallery app, scans every face in the photograph and creates a biometric face template based on their unique facial geometry. Samsung does this without informing anyone and without obtaining permission from anyone. This is precisely the conduct forbidden by the Biometric Information Privacy Act, or BIPA. The district court erred in dismissing the complaint here for two primary reasons. First, the biometrics meet the statutory definition of biometric identifier. The statute expressly defines the term biometric identifier to include a scan of face geometry. And there is no dispute here that there was a scan of face geometry. Second, Samsung, not the photograph takers, collected and possessed biometrics without notice and consent in violation of sections 15A and 15B. Samsung controlled the decision to collect biometrics, the storage, the access, and the use of the biometrics.
Mr. Sostrom, I guess I have a hard time understanding how Samsung controlled the use of the collection of biometrics, given the fact that it is not Samsung who's taking the photograph. So, back for those of us who are along in years, say Polaroid creates a camera, but it's not responsible for taking pictures with the camera. Why isn't this any different?
Because the user is deciding to take a photograph. That's it. The user is not deciding to scan biometrics. That was Samsung's decision.
But if the user doesn't take in, let's say the user just takes landscape photographs because they love landscapes, right? In that instance, the gallery app wouldn't process, there wouldn't be any sort of biometric data the gallery app would process, right? So in the end, isn't it the user that decides whether or not the data is collected?
No, because the user has no insight that biometric data is even going to be collected. They have no idea that this is happening on the device. And so all they're doing is taking a picture. And Samsung co-opted their camera to then process and scan the faces in those photographs. That was Samsung's decision. And this is how this case is distinguishable from Illinois Appellate Court Barnett decision. In Barnett, the users were deciding to scan their own biometrics to unlock their device. That was a feature that was made available to them, and they had the ability to either use it or not use it. They could turn it on, they could turn it off. They could delete their biometric data, they could leave it there. The users of the smartphones in this case had none of those options.
There are a number of Northern District of Illinois cases as well as Illinois state cases, and they hold that there's a difference between controlling or accessing the technology versus the data itself. So to the extent we've got a bifurcation there, that seems to be it. Doesn't such a difference exist when one is alleging, say, possession under 15A?
I think that under 15, I'm sorry, is the question whether access to the data is determinative under 15A?
Access or the data itself. So
Okay.
accessing technology is different than the actual data. And that seems to be the distinction that the case law is picking up.
Okay. So with respect to accessing the data, Samsung did that for its own purposes. The app groups photographs of individuals together based on their unique facial geometry. And the decision to do that is not something that the users decided to do. The decision to access the data for that purpose is not something that the users decided to do. It's something that Samsung decided to do. Through its own software, yes, but that software is an instrumentality of Samsung when the users are not choosing to do any of this.
When we get down to the pleading question, though, doesn't BIPA require pleading direct access to the data, not direct access to the technology?
I'm not sure I would concede that it requires pleading direct access to the data. I think it requires pleading control. I think everyone agrees here that control is a determinative test. And we did plead that Samsung accessed the data, that Samsung accessed the data specifically for this purpose of grouping the photographs together. And that was something that it chose to do for its own purposes.
On that issue of control, so the district court notifies you, hey, I think you've been deficient in your allegations, and you go back at it. Why did you not add additional allegations about the Samsung cloud, knowing that the district court was looking at this issue of control and specifically possession and whether anything at all was left on or kept on Samsung's servers, which is something that we see in some of the other district court cases?
Sure. Well, I think there's two answers to that question. The first is that the Samsung storage on the Samsung cloud is not determinative of control in our view. The second is that we believe that the allegations that we made allow for a reasonable inference that the biometrics were uploaded to the Samsung cloud when the gallery app is connected to the Samsung cloud.
But there's no specific allegation, going back to Judge Jackson Kumi's point, that the face templates were uploaded to the cloud. Is that correct?
It's correct that it does not expressly state that. However, it does state that the gallery app is connected to the Samsung cloud, and that the gallery app, while on the Samsung cloud, allows for the sharing of photo albums. And the grouped photo albums...
Well, at this point, do you have any reasonable basis to believe that, or to allege that the face templates were uploaded to the Samsung cloud under Rule 11?
I think that based on the information we have, we alleged what we could. The Samsung Samsung's website states that the gallery app is connected to the cloud. It states that groups of photos can then be shared across all devices, including with other people. And the way that the app groups photos together is by using biometric information. And so we believe it's a reasonable inference that when it is connected to the cloud, it utilizes those biometrics in the same way.
And then is your position that discovery is what will enable you to connect more dots and find out more about this possession issue? With
respect to the cloud, I think that's correct. And in fact, the Hazlitt case, which is...
Which Hazlitt?
Well, we can start with the first one. In that case, the allegations were not that any of the data was uploaded to Apple servers. The allegations were that the data stayed solely on the user's device. And the Southern District of Illinois denied the motion to dismiss based on similar factors at issue here, which was that the users didn't choose to do this, they had no control, etc. But subsequently in that case, the plaintiffs did find through discovery that the data was sent to Apple's cloud. And they amended their complaint a couple years later to add those additional allegations. We believe we should be entitled to seek discovery to confirm that in this case. But Hazlitt is important not just to show that, but also that the allegations of control, even if the data never uses the device, is sufficient to state a claim for collection and capturing under 15b.
Mr. Sutherland, is there a way for a plaintiff to, given a phone, determine by reverse engineering or otherwise whether or not the biometric data was uploaded or not uploaded? Is that something that is that a plaintiff coming just to a case would be able to determine, or is that something that is solely within Samsung's kind of knowledge?
It is not determinable to my knowledge. So I don't know precisely what the answer to that question is, but we're not aware of a way to do that.
Would you like to reserve the remainder of your time?
Yes, thank you.
Thank you, Mr. Sostrin. We'll now move to argument on behalf of the appellee, Mr. Dvorsky.
Good morning, Your Honors. May it please the Court. Shai Dvoretsky for defendants' appellees. To begin with what I think is the most straightforward path through this appeal, both parties here agree that a private entity can be liable under BIPA 14A and B only if that entity has or controls the data at issue. As the colloquy this morning thus far I think shows, the complaint in this case does not allege that Samsung has or controls the face scans or face templates. What appellants allege in their complaint is that the scans and templates are generated by software that Samsung designs. They allege in the complaint only that the scans and templates are stored on users' devices. They don't allege that Samsung, the company, could use that data or even access it. It therefore makes no sense to say that Samsung had possession of the data, as 1415A requires, or that it obtained it in any way, as 1415B requires. Appellant's argument conflates Samsung's software with Samsung the company. They argue that Samsung software does something that they object to because it's generating face scans and face templates, and so they argue that Samsung must therefore control that data. But BIPA doesn't regulate entities' design of software that might generate biometric identifiers or information. It regulates entities' possession and obtainment of that data. And appellants simply can't get around the fact that their complaint doesn't allege that Samsung controls data on users' devices.
Mr. Dvorsky, I wonder if I could ask you the same question that I asked Mr. Sostrin with regard to when a plaintiff kind of gets a phone and looks at the gallery app and knows that, from the way it functions at least, that the gallery app is taking some sort of face template in order to kind of categorize or group photos together. Is there a way that a plaintiff and whatever experts he or she may require to kind of make a determination as to whether or not the biometric data is uploaded to the cloud versus just the photos?
So I'm not sure the answer to that question in the abstract, but let me answer that question with respect to this particular case, because what happened in this particular case is that the district court, as just Jackson Acumi pointed out, the district court faulted the plaintiffs specifically for lacking an allegation about cloud storage. In response to that, Samsung gave the plaintiffs a declaration that was in the record from another case, declaration from a senior engineer at Samsung, stating unequivocally that the face scans and the face templates are only stored locally on the user's device. The reason that my opposing counsel acknowledged that the complaint in this case, that they pled as much as they could plead, is that that was all that they could plead consistent with Rule 11 in light of that declaration. They had the opportunity to review that information. They had the opportunity to have a dialogue with Samsung about that information, and it didn't get them to the point where they needed to be, which would be to plead, as the statute requires, possession or obtainment. So whatever the challenges in the abstract may be of finding that information, in this case, plaintiffs have gone as far as they can possibly go in light of the devices at issue, and their allegations are simply insufficient because, again, they're not pleading that Samsung actually possesses or has this information.
Does Samsung have access to the gallery app at all? And the reason there are still questions, despite what you're saying right now, there are still questions to ask here. Say, for example, a Samsung user is storing child pornography or any other evidence of criminality on their phone, in their photos. Can Samsung get to that? Could Samsung retrieve those images?
I don't know the answer to that question, but they haven't alleged, it has to be more than speculation at this stage, that Samsung could do something like that. They haven't alleged that Samsung has the ability to reach into the phone in that way. The allegations that my opposing counsel relied on are that the Gallery app is connected to the cloud. But specifically what they're talking about in the complaint is that the photographs can be uploaded to the cloud. Photographs under BIPA are not biometric information or biometric identifiers. And so that's all they've alleged. And
You heard your opposing counsel say that they don't believe that the cloud is determinative of the answer here. In other words, the cloud is not the only means by which Samsung could possess or keep or access the face templates. It happens to be something the district court's talking about and we've talked about, but something could otherwise be in Samsung's control, not on the cloud. They think their allegations allow that favorable inference. What's your response to that?
Well, I think let's look at their allegations, because I don't think that their allegations support that conclusion. They allege three things. One, they allege that photographs can be backed up to the cloud. That's paragraph 75. They say Samsung's Gallery app has a feature that allows users to back up their photographs to a cloud server. For one thing, photographs aren't covered by BIPA. For another, they haven't alleged that any of the plaintiffs here actually use that option to back up even their photographs to the cloud. Two, as to the face scans, they allege that the face scans are stored at least ephemerally, but that's talking about storage on the device. That's paragraph 54. Third, they allege that the face templates are stored at least on the local device. They say, quote, in the solid state memory of the user's Samsung device. That's paragraph 57. And then they acknowledge that the users are the ones who own the device hardware. So the sum total of the allegations in their complaint, anything beyond this is speculation. The sum total of what they're actually alleging is that the face scans and the face templates are stored directly on the user's devices, and photographs, which are not protected, not covered by BIPA, can theoretically be backed up to the cloud. That's all they've alleged. Whether there's something else out there that they could conceivably allege on a motion to dismiss, it's just speculation, and the motion to dismiss has to be judged based on what they've actually put forth in their complaint.
So going back to what you were saying earlier, so Samsung provided the plaintiffs with the declaration from the engineer, and I assume that after that, from what you're saying, there was some dialogue back and forth. And so is your statement to the court here that the plaintiffs had an opportunity after receiving that declaration to engage in additional dialogue with Samsung to try to get more information to satisfy their obligations under Rule 11?
So again, the declaration was provided to them. They could have asked questions about it if they had wanted to do that. I was not personally a part of that dialogue, so I couldn't. All sorts of reasons I couldn't tell you the back and forth, but the primary reasons I don't know, because I wasn't a part of that dialogue. But the back and forth here was, again, we gave them this declaration in order to, we didn't want to go through needless litigation over this. We gave them the declaration. They had the opportunity to ask questions about it. They pled what they pled, and at this point, they're bound by their complaint after three complaints in this case.
There's a capable of identifying requirement within the definition of biometric information, but there is not that type of requirement within biometric identifier. What are we to make of that?
So happy to answer the question. Just before I do, the court doesn't need to reach that issue at all if it agrees with us that there's no possession or obtainment. That would be dispositive of the claims under 1415A and B. Mm-hmm. But to get to your question, Chief Judge Brennan, the Ninth Circuit addressed this issue recently in the Zellmer case. The definition of biometric information does expressly include the language about used to identify. The definition of biometric identifier it also requires identification because we are talking about an identifier, namely something that can identify. The BIPA does not purport to provide a comprehensive definition of what a biometric identifier is. It lists certain things that are included and certain things that are excluded from biometric identifiers. And when you have that kind of a statutory structure, statutory definition, as the Ninth Circuit explained in Zelmer, BIPA isn't purporting to eliminate the common understanding of what an identifier is. And that common understanding is that an identifier is something that can be used to identify.
Why do we?
I'm sorry, go ahead.
No.
But when you use the word identify, I think reading the briefs, it seems like the parties perhaps have different definitions of what they think it means to identify. Is Samsung's position that to identify an individual with biometric data means you have to identify the particular individual's name, rank, and serial number? Or is it enough that if you have 20 people, that the data is sufficient to exclude 19 of them and include just one?
Well, Judge Lee, let me answer that question with reference to what I think is common ground, because it's the other side's definition of identity. They say in their reply brief at page 3, quoting a dictionary definition, that an identity is the distinguishing character of an individual. What the Gallery app does here is that it tells you that the person in photo A is the same as the person in photo B. That's not a distinguishing character. That's not telling you who the face belongs to. It's just telling you these two are the same people. In order to identify, the app would need to tell you who the person is with reference to some distinguishing characteristic, whether that is name, whether that is social security number, whether that, in their police lineup example, whether that is being the person who has committed a crime. But simply saying person in photo A is the same as person in photo B, that's not identifying the person or telling you who it is. That's just matching up people who are in the same photos on the phone.
But I think it's just perhaps a definitional kind of disagreement. But it seems to me that, for that isolating one person out of a group of possible people, as with regard to an external reference, let's say it's someone that you met before, someone that committed a crime, or whatever referent that might be, other than name and name and other identifying information, that seems to me at least sufficient to kind of separate one individual from all the others in the world based upon the facial template. Why isn't that identifying?
I think it's not telling you anything about that person. Again, let's look at the allegations in their complaint. They float two possibilities in their complaint, neither of which helps them. One is that there is a possibility of tagging photos in the app. Two is that there's a possibility of linking photos to photos in contact cards. They don't allege that any of them were ever tagged. They also don't allege in their complaint that contact information was connected to any of their face scans. And so they haven't alleged, again, in their complaint, whatever identifying means in the abstract, they haven't alleged in their complaint that any of them were identified in any meaningful sense here.
I think your argument would have more force if we were not already in a world where facial recognition technology can do so much already and has already been subject to so much litigation and news. But your argument on identifier does ask us to resort to the ordinary meaning of identify. And what I'm trying to understand is why we need to resort to ordinary meaning in that kind of statutory construction when the legislature has specifically defined identifier to include facial geometry, a scan of facial geometry. Why do we then go into the extra steps of statutory construction?
First, because the statute does not provide a comprehensive and exclusive definition of what a biometric identifier is. As the Ninth Circuit explained in Zelmer,
but what we're discussing here is included in that list, even if we agree with you that the list is non-exhaustive.
That's right, but it leads back to the same question of whether a particular scan is a biometric identifier or not, which depends on whether it can identify. There are a couple of other contextual cues that tell us that. One is that biometric information, which is based on biometric identifiers, biometric information has to be able to identify. It wouldn't make sense to say that the biometric information has to identify, but the biometric identifier from which the information is derived doesn't have to identify. In addition to that, elsewhere in the statute, elsewhere in BIPA, it talks about treating biometric identifiers and biometric information similar to other confidential information, and that other confidential information is defined as being able to identify. So again, it's not that every face scan is categorically a biometric identifier. The question is whether the data can identify. But again, going back to what I was saying to Chief Judge Brennan at the beginning of this colloquy, the court doesn't need to wade into any of these issues because the plaintiff's complaint fails at the threshold because they haven't alleged, despite having opportunities to do so, that Samsung possesses or obtained the data at issue.
Thank you very much.
Thank you.
We'll now move back to Mr. Sostrin for rebuttal argument.
Thank you. The statute, the council talked a lot about possession, but there's 15B as well, which talks about collection and capturing. And if Samsung is not collecting and capturing this data, then who is? It can't be the smartphone users that are only taking photographs. If they are collecting and capturing the data, then they would be required to comply with BIPA's requirements. They would be required to give notice before taking a photograph that the subject of the photograph is going to have their biometrics scanned. They don't even know that that's happening. The Illinois legislature did not intend for ordinary consumers to be subject to BIPA liability simply by using their smartphones. What it intended is to preclude entities from collecting biometrics without consent. And that is exactly what Samsung is doing here through its own instrumentality. Samsung didn't just sell software. It didn't create a biometric scanning tool that it then sold to users who wanted to scan biometrics. It sold smartphones and embedded a biometric scanner into the smartphone without telling anyone.
But that seems like facts that might be the basis for some sort of claim between the users of the phone and Samsung, perhaps regarding non-disclosure or what have you. But here you're asserting a claim with regard to the subjects of the pictures in Samsung, right? And so I think that's where, for me at least, it becomes a bit hazy.
I think that additional claim could be made, but I'm not sure why one would preclude the other. I think you look at the statutory terms, collecting and capturing data.
Well, because the first is the claim directly from the user to Samsung deals with an obligation that Samsung had to the user. BIPA deals with what obligation Samsung had to the subject of the photos, right?
Sure.
And so those are, it seems to me, those type of claims are trying to effectuate different rights.
I think that's true. And here we have the subject of the photographs whose biometrics are being collected without their knowledge and consent. So the plaintiffs aren't just alleging that their biometrics were collected on their own devices, but on other people's devices whenever they took their photograph. It would be like if Samsung sold smartphones that recorded every phone call that came into the phone and just stored the recordings locally on the device. Could Samsung say, oh no, we're not recording anything. It's just the software that we sold. It doesn't matter that the data is stored on a device or in the cloud. It matters who is doing it, who is choosing to collect these biometrics. And in this case, we've alleged that Samsung is doing it. The users have no idea it's happening. They have no ability to control any of it. Just briefly on the capable of identifying requirement, it's capable of identifying, not actually identifying. And in this case, we allege, and we quote Samsung's patent that says that the subjects of the photographs could be linked to the contact list. A contact list contains all this additional information that Samsung says is lacking here. So if the patent says it can be linked to that identifying information, and we allege that in the complaint, I think we've satisfied that requirement, even if it is part of the statutory, even if it is a statutory requirement. Unless there are any additional questions, I can end here.
Thank you very much, Mr. Sostrin. Thank you, Mr. Dvorsky. The case will be taken under advisement. The court is calling Appeal 24-2702, United States versus Glenn Wooden, and we'll begin, Mr. Hammernick, with argument from you.
Good morning, Your Honors, and may it please the court. Jared Hammernick for Glenn Wooden. I'm going to do my best to reserve about 3 minutes for rebuttal.
Very good.
We're asking this court to reverse Mr. Wooden's conviction because two instructional errors deprived the jury. The jury was deprived of two important instructions. The first goes to the elements of the offense. The jury was not instructed, despite Mr. Wooden's request, that methamphetamine, as defined by federal law, does not include all kinds of methamphetamine. Instead, it's limited to methamphetamine composed of the optical isomer. The second instruction that was not given at Mr. Wooden's trial was the dual role witness instruction. After United States versus Jett, the circuit crafted a pattern instruction on how to evaluate witnesses who testify both in a lay capacity about what they did in the case and as experts about how to do things generally. In this case, the government's key witness was Mr. Chavez, a forensic chemist. He testified both about how he tested the methamphetamine and how experts generally test methamphetamine. Because of these two errors, we would ask this court to reverse and remand.
Let's start with the first, the methamphetamine question. When we look at the statutes, we look at the guidelines, look at the case law, it is a term, a methamphetamine, that has admitted of differences, D versus L. Methamphetamine has been looked at one way during the categorical approach cases, also in other areas. Wouldn't your client's definition, limiting it to optical isomers, drain the word methamphetamine of meaning? Wouldn't there be nothing left if it was just the optical isomers?
I don't think that's right. In fact, I think it's exactly the opposite. Congress defined methamphetamine in this way, and so that's how we know the substance of the term is based on the definition that Congress provided. The optical isomer of methamphetamine is one type of methamphetamine, but there are others that are not illegal to possess. They are essentially food additives and gym supplements and this sort of thing, which is why Congress has not outlawed their possession.
Once it became clear that there was going to be a debate about this after the first day of the third day trial, there was this request for judicial notice that occurs by the government. The court indicates judicial notice with regard to the illegality of the certain substances. At that point forward, put to the side the whole waiver forfeiture question. Put that to the side. At that point, isn't there an understanding among the parties who are litigating this case as to the substance that is charged to being possessed? And furthermore, that substance itself is illegal.
So I don't think that's right, and maybe I'm misunderstanding the question, but Mr. Wooden's whole theory throughout the entire course of the trial was
to try to convince the jury that the government had not proven that the substance that the government was calling methamphetamine met the definition of methamphetamine as defined, like, under the congressional definition. So when you have this sort of this colloquy about judicial notice and so on, he is still, Mr. Wooden was still resting his argument on, and I think we know this because he later moved for judgment of acquittal on it. He tried to argue this to the jury. He was still basing his defense on the idea that methamphetamine is a limited term, right? That it includes only methamphetamine made of optical isomers. Now, it's not possible for methamphetamine not to be made of isomers. Isomers are just the molecules that make it up. But Congress has specifically said that only some of those molecules are illegal.
I'm wondering there whether if we go down the path that you're asking us to do, whether we might create a circuit split. The Third Circuit, in a case called Julius, examined whether methamphetamine under 841 means D or L, and ultimately concludes that the statute doesn't make a distinction between those two. If we were to draw that distinction, would we be contrary to the Third Circuit then?
So I'll confess I'm not familiar with that Third Circuit case. I don't think it came up in the briefing. I don't think you'd be creating a circuit split, though, because the record in this case does not demonstrate whether D and L methamphetamine can exist in both positional and optical form, or if it's just one, if D methamphetamine is a form of optical isomers or a form of positional isomers, right? So the record in this case doesn't say that D and L methamphetamine are not necessarily distinct from positional isomers and optical isomers. So I guess the point is, what I'm trying to say is I don't think you'd be creating a circuit split because the government may still be able to prove that something is D methamphetamine or L methamphetamine without. I'm not sure whether that would preclude the government from, D methamphetamine may be an optical isomer of methamphetamine. I think Chavez testified actually that D methamphetamine, at least in some cases, is an optical isomer. So I don't think you'd be creating a circuit split.
Let me ask you this. Is Mr. Wooden reading the words any quantity out of the statute and the word including out of the statute, Schedule 2C? In other words, let me flesh this out. Schedule 2C says that any quantity of methamphetamine is against the law, including isomers, salts of isomers, okay? Where you have Chavez on the stand saying, hey, we found methamphetamine, where it's clear to the jury he confessed to having methamphetamine, and where Chavez says, I did a test and I found some optical isomers. Doesn't say how much, doesn't say weight, blah, blah, blah. But he says, I found some optical. How does that not satisfy the statutory definition of where we find any quantity of methamphetamine, including isomers, game over?
Sure, and I appreciate the question because I think what that question is getting at is, was there sufficient evidence for a conviction in this case? And
which is one of his claims.
Yes, but as it relates strictly to the drug quantity. So our primary argument here is that the jury had to be instructed on that point. The jury had to be instructed that this was a critical difference. And so the standard for reversal on an erroneous...
What was the critical difference?
That it was a critical distinction whether or not the methamphetamine was made of optical isomers or not. Right? And the only evidence at trial about the isomeric form of the methamphetamine came on cross-examination by Mr. Wooden of Mr. Chavez. And so because we're raising primarily a jury instruction challenge, what we're saying is that this is a question that had to be submitted to the jury. The jury was specifically told that all of this was irrelevant, that it didn't matter, but that's not right. Under the statute, this actually is a critical distinction because some forms of methamphetamine are outlawed and some are not.
So, I'm so glad.
No, so the only point there is because we're raising a jury instruction challenge, we don't have to show that he would have been acquitted. We just have to show a reasonable probability of a different outcome. And we think there are several here, and that's if we're assuming plain error review, which I don't want to do. The other, if we're on de novo review, then of course the government would have to show it's harmless beyond a reasonable doubt. And I don't think they can do that given that the jury was instructed and the government argued that this whole subject was irrelevant.
So let's assume that we agree with you and that the jury instruction should have been more specific. I mean, in the end, taking a step back, you have methamphetamine that has illegal forms and methamphetamine that has legal forms, right? And we have consistently held that the government can prove the that a substance is illegal, prohibited by the statute, via circumstantial evidence, right? And so here you have Chavez saying that, he did some tests and he found the D optical isomer, and he also did some other tests and he found that all of the meth was pure. And there's also lots of evidence that at least Mr. Wooden believed that the meth he had was the illegal kind, not the legal kind, because he took all of these steps to avoid capture and detection, right? Why, taking all of it together, isn't that enough evidence for the jury to find that, well, here, to convict Mr. Wooden of possessing the illegal type of methamphetamine, therefore rendering any jury instruction deficiencies that we might find to be harmless?
Sure, because none of that tells you what the molecular composition of the substance was.
But why do we need to know that as long as we know that we're dealing with the illegal type? That is, obviously it's the optical isomer, but as long as we're dealing with the illegal type, and everyone knew that we were dealing with the illegal type, and Mr. Wooden believed that it was illegal, and certainly he wasn't selling food additives, why isn't that enough for to sustain the jury's the verdict in this case?
Because the government had to prove beyond a reasonable doubt that the methamphetamine was methamphetamine as defined by federal law, right? So it was not Mr. Wooden's burden to prove that the substance was uncontrolled. It's the government's burden.
But I guess my question is, why doesn't all the circumstantial evidence that the government presented meet that burden?
Right, and I think it's because what we're talking about here is a distinction that's drawing a line at the molecular level, and none of that tells you what kind of molecule was involved in the substance.
Well, again, but doesn't the fact that there's illegal kind and the legal kind, and here we're clearly dealing with the illegal kind, doesn't that go to that question?
Well, I think we're clearly dealing with what everybody may have thought was illegal, but this is a point that the government has to prove beyond a reasonable doubt. So, I think in some ways I wonder if we're missing the forest, and I've been asking myself this too, I wonder if we're missing the forest for the trees here because we're dealing with organic chemistry and molecules and isomers. If Congress passed a statute that, said that it's unlawful for anyone to possess a firearm, and then in a separate statute said, well, we define firearm to mean machine gun, the government couldn't just walk into court and convict somebody for possessing a firearm without proving that the firearm was a machine gun, right? The congressional definition of the term matters.
Relevant to that inquiry, what if the government, had wiretap recordings and the defendant says, hey, I'm going to sell you a machine gun? Like, that would be relevant evidence, right?
Sure, it would be relevant.
Whether or not it truly was a machine gun, the fact that he thought it was a machine gun is relevant evidence, that inquiry.
So it's certainly relevant evidence, but if that existed, but then the government also walked in and argued to the jury and got a jury instruction that essentially it doesn't matter if it's a machine gun, it doesn't matter if it's the wrong kind of methamphetamine. That's why we don't know what the jury would have done, because the jury was instructed that all of this was irrelevant and none of it mattered.
Would you like to reserve the remainder of your time?
Sure, I'll do that.
Very good. Thank you, Mr. Hamernack. We'll now move to argument on behalf of the government. Ms. Boyle.
Good morning, Your Honors. May it please the Court, Counsel, my name is Catherine Boyle on behalf of the United States. On appeal, Mr. Wooden is primarily arguing that the District Court erred by failing to offer jury instructions that include the federal definition of methamphetamine down to the optical isomers as an element of each of his offenses. Mr. Wooden has arguably waived that objection, but regardless of that, he has at least forfeited any objection to the jury instructions as to the elements of his distribution offenses and the possession with intent to distribute offense, and therefore plain error review should apply here. Mr. Wooden's initial...
Did he really forfeit it, though? Because, he has made this objection all the way through. The court recognized that he had made this objection and said that, I'd ruled against him before the court went through the government's jury instructions. All we have is a rote in a question and him just saying no objection. In other contexts at least, we question whether those sort of fact scenarios are even sufficient to show forfeiture, let alone waiver.
Well, Your Honor, I think if you look at this, I think the district court was trying to get this right here. If you look at Mr. Wooden's initial proffered instruction, he said that the jury must find beyond a reasonable doubt that the defendant knowingly and intentionally distributed methamphetamine, its salts, isomers, or salts of its isomers, and then he references Section 812. That initial proffered instruction, you might say it only pertained to the distribution offense, but he actually later mentions possession with intent to distribute, so arguably it applies to both. But it doesn't even mention Section 802.14, where the term isomer is defined, and it doesn't say anything about optical isomers. And then Mr. Wooden objected on different grounds to the proposed pattern instruction for the possession with intent to distribute offense. In that case, he suggested the government had to prove that he knew the substance contained methamphetamine or its optical isomers. And the district court went into that. I think the district court was trying to figure out exactly what he wanted out of these instructions. The court then confirmed that Mr. Wooden wanted the instruction to follow his proposed instruction, which, as we've discussed, does not define the term isomer. And then the court said, well, I'm not going to do that. I think the government's proposed instruction is based on the pattern and it's an accurate statement of the law. So I don't think during the jury instruction conference here, Mr. Wooden specifically preserved a request for a jury instruction that defined the methamphetamine as optical isomers, referencing the federal definition.
Let's talk about this definition. So the Controlled Substance Act of 1971 makes meth Schedule III controlled substance. Statute never defines the term. The statute makes both methamphetamine as well as its optical isomers controlled substances, but it still doesn't purport to define the term. Our case law is less than fully clear. We seem to have a certain definition within the categorical approach cases, other than non. What definition should we utilize?
Well, the government agrees that it has to prove methamphetamine is a controlled substance in every case. And we think that the government did that here. The government conducted routine testing. When the defendant's questions about isomers, salts of isomers came up, the government said the government was able to show it was D-methamphetamine, which is an optical isomer based on the testimony of Luis Chavez. Mm-hmm. The district court, as you've noted, has said in some of its prior cases that methamphetamine in the categorical approach context, such as De La Torre and other cases, that methamphetamine under federal law in those contexts should be limited to its optical isomers. Methamphetamine is essentially in multiple different forms. You have liquid methamphetamine, which is usually a combination of D-methamphetamine and L-methamphetamine. And then you can also see methamphetamine in the isomeric and salts of isomers form. In this case, we were looking at a salts of isomers form of methamphetamine, which is ice-methamphetamine. And when you're looking at the salts of isomers in this case, and you look at the federal definition, it does say that the isomer in question, isomers for methamphetamine would have to be an optical isomer, which we agree was present here. As to whether methamphetamine generally can be a more blanket term, I don't think that's entirely clear on the record of this case, and in the case law, I think it's a little bit muddled still.
Would the definition of methamphetamine that's being offered by the defense drain itself of meaning, because you'd be making distinctions based upon the optical isomers and not just a more general version of methamphetamine?
I think the main issue with the definition of methamphetamine being offered by the defense as it pertains to this case is the specificity is just not needed. Jury instructions can always be more specific, but you want to look on a case-by-case basis and determine whether that specificity is warranted. And in this case, and I think at times it can also be more confusing to all of a sudden be presenting an isomer issue to the jury in a case like this one, where it's extraordinarily clear from the record that the chemist found demethamphetamine. The chemist said demethamphetamine is an optical isomer. We have a significant amount of other evidence showing that Mr. Wooden knew he was dealing in illegal substances, including his avoidance of police contact, his avoidance of police contact, him saying he knew the customers were going to like it, suggesting it would have a psychoactive effect on them, his acknowledgement that it was hot. Really, the entire circumstances of the case here showed that this was methamphetamine that was illegal under federal law. That you could also think about this court's decision in United States versus Page in this context. There you had an issue as to whether a buyer-seller instruction was warranted, and the court determined that it wasn't because it wasn't supported by the evidence of that case. Conspiracy is something the government needs to prove in that case, and the buyer-seller issue is certainly a nuance of conspiracy law, but you don't need to have that level of specificity in the jury instructions where it's not warranted. And we would say here it's not warranted based on a substantial amount of evidence in this case that the type of methamphetamine that was being dealt in here was clearly illegal.
What troubles me about this case and the way that the district court and the government handled this case is that, at least in one reading of the transcript, they just completely ignored the definition. I mean, the defendant, brought the issue up in whatever context, but certainly as a trial judge, one would know that this is an issue that the defendant wanted to make, and particularly at the cross-examination of a phase, something the defendant wanted to make. And in my reading of the transcript, the response from the court and from the government is that, it really doesn't matter as long as we prove, quote unquote, meth. And that seems to me, the reason why it troubles me is because it does seem to be somewhat inconsistent with the government's obligation to prove the elements of the offense, and one of the elements being that the substance is a controlled substance. And so I'm curious, and I get what you're saying about case by case. That's true of any kind of jury instruction and whether or not jury instruction is necessary. And, we give district courts broad discretion in determining whether or not a particular jury instruction is warranted. But can you describe me of a case where you think that a district court is obligated to give a more specific definition of methamphetamine versus to contrast it to what we see here?
Your Honor, I think if the defendant had presented an expert witness suggesting that perhaps the methamphetamine present was not an optical isomer, that would be a case where...
But then aren't you putting the burden on the defendant to kind of disprove an allegation, whereas it's the government's burden to prove in the first instance that it is a controlled substance? And that's what disturbs me about, there's that First Circuit case and the Sixth Circuit case that talks about theory of defense. It seems to me that whether or not a substance is an illegal substance is one of the most basic elements that the government would have to prove in a drug case.
We absolutely agree that the government has to prove that the defendant was dealing in a legal controlled substance in a drug case, and the government routinely does the sort of testing that does prove that. You can see in this case, even though on direct examination, the chemist hadn't had his testimony get down to the granular level of optical isomers. That is why he concluded it was methamphetamine. He does his first test where he basically determines that the chemical formula is present, but then he goes on and he tests for salts and he tests for isomers. And we absolutely agree that the government has a burden to prove that, and we believe the government routinely does it in this manner. But that said, I think it does make sense when you're looking at what jury instructions make sense to issue to look at the overall evidence in the case and decide if it's warranted. And here, where you have so much evidence, including the isomers, frankly, and you have no contrary evidence suggesting that that is incorrect, we don't believe you need to get down to the level of specificity of optical isomers in jury instructions.
Can you include the isomers fairly in that evidence? I mean, Chavez did not say how much optical isomers he found. can you tell us, do you know if it's scientifically possible to determine in a drug weight finding what percentage of methamphetamine consists of optical isomers versus other types of isomers? He just, what I'm getting at is what we have is a more general statement from Chavez. I found optical, but we don't, he did not connect it to a percentage, weight, anything. And then otherwise we just have some numbers. It's this much actual methamphetamine. But you can't fault Wooden for thinking, you know, once he sees our categorical approach case law, that there needs to be some more specificity when it comes to optical isomers. If you lost my actual question after I added all that, just let me know.
Well, let me know if I'm not answering it well, please.
Okay.
I'll do my best. So just sort of initially to take a step back and then go into your question, as your honors pointed out earlier, the chemist had identified the D-methamphetamine isomer, and that's an optical isomer, and that's enough to show that this substance was illegal. I think what you're going toward more, your honor, is the ratio of the substance and the drug weights and the defendant's challenge on the sufficiency of the evidence to those. And I think on those we do, especially given the standard of sufficiency of the evidence, there is enough here. If you look at what the chemist did and what he testified to, he testified, you know, he figured out the net weight, he figured gross weight, net weight. He did a purity test where he took very careful steps to make sure he had a composite powder, and then he would figure out the purity percentage. And he performed the gas chromatography mass spectrometry test, which showed the presence of the correct chemical formula. And then he went and he figured out the salt form and the isomer form, which in this case was D-methamphetamine. When you look at, and the defendant didn't actually end up introducing the chemist reports, but they were attached to his proposed trial exhibits for your honor's review. When you look at those reports, they do say, you know, the substance ID'd, and they note that it was a salt of D-methamphetamine, and they note the amount of pure substance. And I think that's essentially what the chemist was trying to get to in his testimony when he talks about he has, you know, 12.5 grams of pure meth, 26.3 grams of pure meth, and then these various other amounts of pure meth. I think a jury could reasonably conclude on that evidence and on that testimony that he had done the test, this substance qualified as illegal pure actual meth in a amount that was sufficient to trigger the drug weights when you look at all the evidence in the record on it. But I'm not sure if that exactly answered your question, so please let me know if there's anything else. I just want to add, I only have about one more minute. I do think that there are obviously sort of two lenses the court is being presented with here, and one is this theory of defense instruction idea, and the other one is this idea that there was some sort of missing element. But I think they both can turn on this idea of how specific you need to be based on the evidence that was presented at the trial. And I think in a case like this one, it's very clear that all the evidence at trial showed that the methamphetamine was illegal. And for that reason, we don't think that any jury instruction as to isomers was necessary here, but even if this court were to determine that it was necessary, there certainly wouldn't, the defendant's substantial rights wouldn't have been affected in this case. You wouldn't see a different outcome where you have the chemist actually testifying there is D-methamphetamine and it is an optical isomer. And similarly along those lines, it would be a harmless error because you have this testimony. So although we don't believe that you need to get that specific at the jury instruction level, in this case, we don't believe it would have changed the outcome either way. I see I'm out of time, Your Honors. Thank you so much. If you have any further questions.
Well, thank you, Ms. Boyle.
Thank you.
Mr. Hamernick, we'll recognize you now for rebuttal argument.
Thank you. Just briefly. So I think there was a question whether or not the record demonstrates that methamphetamine is an umbrella term. Mr. Chavez testified at trial. This is record 202, page 89. He was asked, is it true that methamphetamine is a chemical name? It has multiple chemical names, as you testified to earlier. He responds, yes. There are numerous names that methamphetamine can be used to identify. So I think the record does show that methamphetamine can mean multiple things, and that's why it's important for the government to prove as an element of the offense that the methamphetamine was made of optical isomers and not just methamphetamine of some kind. Briefly on the question of the standard of review and preservation. Record 206, page 73, it's the transcript where they're going through the jury instruction conference, and the judge says specifically that Mr. Wooden was objecting on all 4 counts and recognizes that his objection was to all 4 counts. So I don't think that the argument that we're making now is forfeited, let alone waived. At the end of the day, the government has to prove beyond a reasonable doubt that any elemental instructional error was harmless. And I don't think they can do that when when the government at trial specifically argued to the jury that isomers, zips, these are all chemical names for methamphetamine, but they didn't prove the one thing that Mr. Wooden centered his whole defense on. Now, I'm not sure it was the wisest strategy to tie his trial strategy to this one thing, but I think at the end of the day, he was right? Because this court has said in at least 3 categorical approach cases that the difference between positional isomers and optical isomers is a difference of element. It's an elemental difference between state offenses and federal offenses.
Isn't that a tough argument to make, though? Because at least one of those cases, it's really grounding in Indiana law versus federal law. In the categorical approach, those circumstances, they're not getting to an element of the offense that went to what this defendant was objecting to. If we grant you that there's not a waiver and there's not a forfeiture, and we're getting to this because of his persistence in continuing to raise this, I'm unclear. Is this a broken clock is right twice a day type objection? Or is this no, this is grounded in a definition in the statute or a definition in the case law that he is raising and isolating and therefore is exculpatory?
Sure. I'm not sure those are mutually exclusive.
Okay.
But the point is, I think, so he latched on to this point that has been developed over the last several years in the categorical approach case law, where the difference, the categorical approach, as Your Honors are all too familiar with, is all about elements, right? And so when we're comparing the elements of the federal charge of methamphetamine possession, it is narrower on this specific point, on the definition of isomers. Right, and so that's why it's part of the elements of the offense. And so, Chief Judge Brenner, earlier you asked about a circuit split. I think we'd be creating an intra-circuit split if we say, that this is essentially Schrodinger's element. It's an element for the categorical approach. It's not an element on direct appeal.
And I know you've told us, but tell me one more time why Chavez's testimony that he found D-methamphetamine and an optical isomer. I don't know whether the article is "and," but he says found optical isomer, why that is not sufficient.
Sure. So it's not sufficient on our jury instruction challenge because his testimony, yes, he said that, but his testimony was also all over the place. He contradicted himself. The government even told the judge that he didn't check for the isomeric form. And so it's not, so as it relates to the jury instruction challenge, I don't think the government has proven it's harmless beyond a reasonable doubt for this issue to have been taken away from the jury. And then as it relates to our sufficiency of the evidence on the drug weight, that proves that basically an 841B1C offense, there was some amount of prohibited methamphetamine present, but there was not. But there was no evidence that about how much of the total substance was comprised of optical isomers, and so that's why there was not sufficient evidence for the jury's finding on the drug weight. So I hope I've answered your question.
Thank you.
Thank you, Mr. Hamernick. Thank you, Ms. Boyle. The case will be taken under advisement. We'll move now to Appeal 25-1577, Archeo LLC versus Sagiza Incorporated. And Mr. Taney will begin with oral argument from you.
Morning, judges of the panel.
Morning.
May it please the court. My name is Frank Taney. I'm here on behalf of Archeo. I want to cover 3 topics with my principal time. The facts giving rise to Sagiza Inc.'s liability for each of the 6 torts that are alleged here. The second is Archeo's spoliation motion, and the third is Archeo's motion, 59E motion, based on new evidence. And I'm going to refer to Segeza Inc. as Segeza, differentiating them from their subsidiaries that I'll call Segeza UK and Segeza India. Segeza's fingerprints are all over the scope of this project, okay, and they are Chicago footprints. The computer, the Archeo computer, was sent at Segeza's direction to Chicago, not the UK, not India. That is something they answered. They admitted in their answer in this case. Their project manager testified that they wanted to use that software because it had Archeo's code, and they wanted to use that code to help develop the replacement application. Okay, they then proceeded to set up a test lab in Chicago. Again, not in the UK, not in India. So anytime they had to test the entire application, they're going to test that in Segeza's offices in Chicago. They maintained that, they maintained that test lab in Chicago for a year until Archeo served a subpoena on them. At that point, Archeo was litigating against Cummins, who, Archeo contends was a joint tortfeasor with Segeza. They maintained that test lab until Archeo subpoenaed, seeking the software. Then they dismantled that test lab. The code that our expert, Dr. Ricardo Velarde, testified about, he goes into great length in terms of what the dates are on the files that comprise this software. This is a case where Segeza UK contracted with Metro in May of 2016, a full month before there was any contract. Okay, the record is clear that the bulk of the software was available as of April 8th, 2016. Okay, that team members from the United States, including Josephine Yang from Segeza, wanted to meet with Cummins, who also had their main offices at the time in Chicago, and say, hey, we have an application here that is ready to test. And this is all before Segeza UK's signed the contract or part of anything.
Is there a specific part of the Archeo software that you contend is entitled to trade secret protection?
Yes, Your Honor. Those are 10 areas of functionality that are articulated in Dr. Velarde's report.
Why are those not just common functionality? What makes them particularly trade secret protected, and what steps then did Archeo take to protect those?
Sure. In this case, the customer, Metro, needed software that would interoperate with a very particular type of coin counting machine. This was made by, there are other coin counting machines out there, other companies, Coinstar, De La Rue. Cummins made a machine called the MM2. Archeo was, at the time that Archeo developed the software, starting in 2009 and continuing until they were terminated, were the only company that had developed that kind of software. So if you, and these are machines that require, the Cummins coin counting machine requires inputs from the graphical user interface. So I'm here in the bank, I want to deposit $50 worth of coins, I'm typing things in. That's sending, the software underlying the GUI, the graphical user interface, is interacting through the middleware and interacting with the coin counting machine itself. Therefore, it has to, the vendor creating that has to acquire that knowledge, which Archeo had, about how to make that work. I believe that your question was, and then Your Honor wanted to know what were the measures. Well, the measures to protect, we had employees sign, understood that they were under confidentiality obligations. We kept the things secret. We required Metro to keep the software confidential. We required Cummins to keep the software confidential. We had a 45-step configuration sequence that was known only to Archeo, that was not published, not made available to anyone else that Archeo wasn't working with. This is how you configure the software. And there's also there's a couple different types of software had to come together in this application to work. Archeo had base software that was installed on the computer, and then depending at various points in time, as Archeo went and updated the software as Metro's needs and desires changed, that software had to change, but had to work with the base software. So Archeo did not make this available to members of the general public. The code was not available to members of the general public, would not have been available to Segeza, for example.
Counsel, and typically in software copyright cases, a plaintiff comes forward and alleges that particular lines of code were copied, right? Because that's what the Copyright Act protects. Here, I don't think there's any allegations, and there have been no statements by Archeo's experts that there were any particular lines of code that were common between the Segeza software and the Archeo software. And Segeza makes much of this in their briefs. How do you respond to that?
Yes, there's a line of cases in the Seventh Circuit and elsewhere that state when you have a idiosyncratic, like a footprint or a fingerprint rather, that's in the that's evident either in the software or otherwise, that the normal inquiry can be truncated. And here we have a situation where the version that our expert got to examine, we certainly contend it was not authentic, it was not complete. Apart from the code, there is contemporaneous artifacts of development. There are emails. There's an issues list. There's things like that show...
Did your expert undertake analysis to determine whether there were identical lines of code between the two types of software?
He did. He did not find those in the version that he got to analyze. What we did also see, and that's what we found base our case on, there's no innocent explanation when you're testing. This was software that was supposed to be independently developed, right? And when you're testing your software on a clean machine, right? We had one make model of a laptop. They wanted to go with a new Lenovo. Okay, they're using a Lenovo. Archeo's name and logo shows up and displays, right? There's no innocent explanation. Archeo is an arbitrary term, right? Its logo is an arbitrary logo. It's not a proper English noun. There are other examples underlying that. The issues list, right, are quite instructive, right? You have a feature. So this is a coin counting machine that gets put in a lobby of a bank, right? And there's tellers that need to know, hey, there's something going on. You got to get up and go over there and fix this thing, right? So Archeo, with Archeo's experience, they programmed in a knock, right? And that shows up as a bug on Segeza's list, right, in the software that they're developing. It wasn't a bug, it was a feature. The reason that Segeza didn't know it was a feature is because they didn't create the original software that they were working with. The full bin limit issue is another issue that Archeo, in developing its software, so there's a mechanism for sort of letting the machine know, hey, the coins are starting to stack up in the bin here. They're not all the way full, but you're going to have, and these things are heavy, like 800 pounds worth of coins, right? So Archeo's software, our development team had a problem in developing that feature. And it was the same feature, the same problem that Segeza encountered. And our expert says there's no innocent explanation for two software development teams working independently, encountering all three of these telltale signs that the origin of the code at some point was Archeo's. And the spoliation motion is particularly relevant because it's clear the dates on the software do not match up. The contemporaneous stuff, we know that they were continuing to modify the software into 2017. There's no dates past the summer of 2016 in the code that we got to use. Those don't match up. Those raise issues of authenticity. So that That is a significant part of the story here on the analysis of the software. The trade secret, one of the things that the Defend Trade Secret Act prohibits is unlawful reverse engineering, okay? So Archeo had a contract that specifically forbade Metro from using our software in a reverse engineering effort, right? And so when they violate that contract, contractual obligation, hand the software over to Segeza, that becomes wrongful reverse engineering. So all these efforts, and the other thing that we don't see, because the source code repository is not produced, if you have a feature in software on day one, hey, Archeo's name and logo is showing up, it's July 1st, what's going on, right? In a source code repository, you would say, okay, the version that was July 19th, that's where we took it out. And here's the code, and it was Joe Reynolds that put it in, it was that date, and here's what he did to effect that change, okay? We don't see that because we don't have the software repository to enable it. What we have is a static one set of code, okay, that does not match up to the timeline.
Let me ask you a question that something you just said is related to. You said, you know, Archeo and Metro have a contract. The contract prohibits reverse engineering. Archeo hands over this computer to Metro via Cummings, and then Segeza gets it, does reverse engineering. That's wrongful. That gives rise to a claim here. Am I wrong when I look at that Archeo Metro contract and I see an English choice of law clause, okay, which explains also why you were proceeding in England, a choice of law and forum selection?
Yes.
Okay.
Yes.
Does that just not matter here at all because now you're suing Segeza?
Yeah.
But the thing is, with the example you just gave, the obligation not to reverse engineer, that flows to Metro, and you're taking that and saying, you know, Segeza is guilty of that too.
Well, Segeza knew that it was violating this obligation of that it was obtaining this information wrongfully, right? We did not have a contract with Segeza, right? We had a contract, we had a binding legal obligation with Metro. They did not have the right, Segeza, to that software. We did not give it to them. We did not give Metro permission. We did not say to Metro, you can show that to Segeza. So that's why we believe that the reverse engineering that went on here was wrongful.
Would you like to reserve the remainder of your time?
Yes, Your Honor.
Very good. Thank you, Mr. Taney. Ms. Patel, we'll turn to you now for argument on behalf of the appellee.
Sorry. Good morning, and may it please the court. My name is Plak Patel, and I represent the defendant appellee, Segeza, Inc. And we move the court to affirm the district's court judgment, which correctly found Archeo's claim to be devoid of factual or legal basis. The core facts are undisputed. Archeo lost its client, Metro Bank, because its software was obsolete, running on Windows XP and Flash technology, and lacked crucial remote management features. Archeo's entire appeal is a speculative attempt to recover for a purely commercial loss that stemmed from its own failure to innovate. The district court was correct because Archeo failed on two foundational elements for every single claim that it asserts. One, Archeo produced no admissible evidence establishing the necessary legal relationship or direct involvement to hold the U.S. parent company, Segeza Inc., liable for the acts of its foreign subsidiaries. And two, Archeo failed to meet its burden of proving any protectable IP right or any substantial similarity between the softwares, a requirement this court has correctly concluded, or the district court correctly concluded, reflected a broad deficiency Archeo's case as it plays fast and loose with evidence.
Let me just draw your attention to one thing that Mr. Taney just mentioned, which is Archeo's insignia popping up on this, and you all know it in your briefs. It's one computer, it's one time, but it does pop up. The logo appears. on the computer running the Sageza software in 2016. Isn't there a material factual dispute about that? And if so, why wouldn't that preclude summary judgment? Why shouldn't we take, since we have to construe everything, construe the facts in favor of Archeo right now, at least on the copyright claim?
So, Judge, it's important to consider the whole setup of the coin counting machine in considering this one situation. So the coin counting machine consists of two computers, one being the one that consumers access, and then it has the coin counting hardware, and then there's an onboarding computer, an administrative console within the actual coin counting machine. So that is separate from Sageza software. The Sageza software was not loaded onto this onboard computer. It was purely on the computer that the consumers interact with. And this is what was specifically said in the document. So, my apologies. So the word Archeo was only appearing on the onboard computer, the administrative console, and that's unrelated to the Sageza software. And it's important to consider that this whole system, so the actual coin counting machine hardware, the administrative console, did previously have the Archeo software. And so it appearing on this computer was innocently explained by it being a vestigial artifact of the hardware previously having the Archeo software, especially when you consider what was displayed on the screen, which is Archeo's name and phone number. The record shows that Archeo conducted maintenance services on these machines via Cummins. And so it makes sense for the administrative console to show Archeo's name and number if it's showing that there's an issue with the machine that they would need to then service. Sageza never provided maintenance services for the computer. It was not involved with anything in terms of deciding the hardware or maintaining the hardware. Its role was solely limited to the Sageza software, which Archeo admits was only located on the Lenovo computer. And so really this is a red herring. And again, this goes back to the fact that, even if Archeo's argument is taken as true that this is a proverbial smoking gun, this would be something that would be seen in the software. And Archeo to date has not pointed out anywhere in the Sageza software where the word Archeo appears or that there's any similarity between at all. And counsel made the contention that there's case law saying that when there's instances of fingerprints that we can do away with the analysis of substantial similarity. However, I'm not aware of any such case law, and I'm not aware of any case law that was cited as such in Archeo's brief as well.
Let me turn you to another thing I'm looking at. How can we affirm the district court's denial of sanctions when the district court did not explain it? Don't we have case law that says district courts need to explain their sanctions decisions, and we have to send it back when they don't do it in a way that allows for appellate review, meaningful appellate review? Here in the district court's second opinion, we have one footnote that says, oh, and I did look at that. I did consider plaintiff's argument that defendant had spoliated evidence that plaintiff deemed relevant to its claims and concluded that it lacked merit, period.
And so the judge did put that in a footnote, but in the opinion, the judge stated that Judge Bucklow declined to do a fact-by-fact analysis because of the wholesale deficiency of Archeo's factual statements and its briefing, and then further, it made its ruling on Archeo's own admissions, which contradict its argument regarding spoliation. And so, if we look at the record, Archeo admits the fact that Sageza India produced the entire contents of its repository. It was a blatant admission that we produced multiple versions of the code, manuals, descriptions. The whole work product in the entire repository was produced, and Archeo admits that in its summary judgment briefing. Yet in its subsequent briefing and before this court, now it says it wasn't produced.
But doesn't all that go to her decision on the merits about the spoliation issue? How does that substitute for an explanation of her sanctions decision?
Judge Bucklow's explanation was simply that she didn't find merit. And, I do think that it goes towards the fact that the record shows that there was no merit, that RKO itself is contradicting itself and is attempting to make arguments unsupported by the record in order to manufacture a dispute that does not exist. One of the cases cited by RKO states that, for an abuse of discretion, a decision is left unexpected or not when it's not apparent from the record. And so here, I believe that the district court did not commit an abuse of discretion because it's shown clearly on the record that the arguments were meritless by RKO's own admission, and also through subsequent evidence in the record, including multiple affidavits by Segeza stating that it produced multiple lines of this, or multiple versions of this code, an independent production by Metro Bank of the code at issue, and verification by Segeza's expert who did actually look at the code that stated that this is a full and complete copy of the code. And of course, RKO's own admissions that it received a full copy of the source code and a full copy of the repository. But it also goes back to the issue of the relevant parties. Segeza Inc. never worked on the actual back end of the source code. The source code was not maintained by Segeza Inc. It was solely maintained by Segeza India in servers based at its location in Bangalore. And so these copies of the source code were produced by Segeza India. What RKO has failed to establish is what obligation Segeza Inc. had to produce the software, or how they would even possess the software, considering that it was not located on their servers. This was not a project that they were directly contracted to complete. This was a project that Segeza UK was contracted to make, and they subcontracted services to Segeza UK and Segeza US, or Segeza India and Segeza US. And Segeza India was contracted to do the actual software, the back end of the software. And so it makes sense that the source code was entirely housed by Segeza India. Segeza Inc. was merely subcontracted by Segeza UK to work on the user experience, the graphical user interface, which is just the general appearance of the software. So the animations, what a user would see when they go to the console, and like the pages that they would flip through in order to get through the function of coin counting machine. And there's been no evidence to the contrary, despite RKO's attempts to rewrite the record. In their brief, they state now that Segeza US employee Akhil Gopal Krishnan created the back end of the software. Yet, in the motion for summary judgment, they admitted that Akhil Gopal Krishnan, as evidenced by his extensive testimony, only worked on the user experience, which he stated again and again, and that Sri Kapalan Gupta and Vikas Valsang from Segeza India were the employees that worked on the back end of the software. So, next I do want to turn to RKO's general discussion of the copyright claims. And so, as I mentioned before, we're not aware of any case law that indicates that RKO can do away without showing any substantial similarity between the software. This case has been pending for years, and this is almost a third bite at the apple. And to date, RKO still cannot show any similarity between the codes. And it admitted such in its argument. And this shows light as to why RKO is making these spoliation claims that have no basis in the record or in evidence, because this is the only way that they can survive a motion for summary judgment. And, as the district court concluded, there was no analysis of the code. There was no evidence that there was any similarity. There's no case law indicating that RKO can do away with showing similarity. And even more so than that, RKO has failed to establish any access to the RKO software. It refers to an RKO computer. Of course, tellingly, it does not give a make, model, serial number, any details associated with this computer. It states that this computer belonged to them, yet the record shows that this computer was taken from a Metro Bank location in Chelsea. And this is established by documents produced by Cummins, who was in charge of these locations at Metro Bank. And there's nothing in the record besides Archaeo's own statement that shows that this computer was owned by anyone besides Metrobank. But moreover, Archaeo doesn't show that there's anything special about this computer that would not be to anyone else. Yes, the computer may have at one point had the Archaeo software in executable format, but that's no different than someone having Instagram downloaded on their phone. That's not appropriation. It contained no source code by its own admission, and the record is devoid of any evidence of reverse engineering. There's no discussion, there's no communications working further on this tablet. In fact, the record shows that within days of receiving it, Metrobank had made the decision to switch to an entirely different computer system, and the tablet was disregarded because the team was focused solely on a Lenovo computer on an upgraded system. By Archaeo's own admissions, its software could not even work on this Lenovo computer. Archaeo testified that it had tried using its software on a system besides Windows XP. It tried using its software on Windows 8.1. It tried using its software on Windows 10, and it did not work. And so once Segeza and Metrobank pivoted to this Lenovo, which was Windows 8.1, it's uncertain how Archaeo's code could have even been usable. Especially on an upgraded system, based on its own admission that its code would not have worked on the system. So it's perplexing how outdated technology could have informed something that was new and upgraded. It's not a direct translation, and by Archaeo's own admission, it would not have worked. Even more concerningly, Archaeo's software used Flash software, which was outdated. By 2017, Adobe had already announced that it would no longer be supporting Flash. And so Segeza software has no reference to Flash because it does not use Flash. And so it's not a direct translation, and Archaeo fails to kind of explain how these outdated technologies and this outdated code could have even been relevant to the Segeza software. So not only is there no evidence of actual access, when we look at the codes themselves, there's no substantial similarity, nor could they be substantial similarity because of the lack of congruity between the type of technology that's used. And in light of that, Archaeo has now harped on this spoliation claim despite its own admissions that the software was produced. And it made the argument that certain files were dated. However, it does not refer to what version of the Segeza software it's looking at. There was various versions worked on from March through the winter of 2017. It does not tell you what version, the date stamp of the document, and it doesn't even tell you why these file dates are important. Just because there's an older file date doesn't mean that there's a newer one. And so this wholesale lack of ability to give citations to the record is really what's commonplace in the arguments. And it's because of those 2 points that I urge this court to affirm the district court's ruling, that generally, 1, that Archaeo has produced no evidence that directly implicates Segeza Inc., and 2, that Archaeo has played fast and loose with its evidence and failed to meet any burden on any respect by simply making assertions that are not supported by the record or evidence before the district court and before this court. So I think this court quits time.
Thank you, Ms. Patel. We'll now move to rebuttal argument. Mr. Taney, from you.
Thank you, Your Honor. 2 points I want to address. If you look at what the actual emails discussing the appearance of Archaeo's name and logo, they don't mention administrative console. They also ask someone in the email chain who's from Cummins, could it be coming from the Cummins machine? No, he says. That's not where there is no Archaeo source code on the Cummins machine, and there is not.
So it wasn't from the administrative console that the Archaeo name came up?
Right. It was from the onboard computer. You will look at the emails, and administrative console does not appear. You will also see from Cummins, it's like that's not coming from Cummins. Okay. Also, we submitted, their expert did not talk to anybody who actually did any of the coding, okay? We submitted an affidavit from Mr. Tustin, who's in the audience, from our expert. They actually analyzed the operation of the software. They explained how the RKO appeared, they examined it. Also say we do not know what was on the RKO computer because that disappeared. Okay, and your honors can look at the record. This code we had to examine was delivered after the close of fact discovery. We had to extend the discovery schedule because they finally produced it after I confronted them. So the spoliation evidence is very real.
Thank you, Mr. Taney. Thank you, Ms. Patel. The case will be taken under advisement. We'll now move to Appeal 24-2682, Kelly Lomax versus City of Chicago. Mr. Flaxman, we'll begin with you.
May it please the court. The defendant police officers in this case arrested Javario Kelly Lomax and charged him with possessing a gun. At the time of the arrest, Mr. Kelly Lomax was sitting in a car. There were 3 other men sitting in the car. Kelly Lomax was in the passenger seat, and after removing all the men from the car, police found a gun hidden under the passenger seat. We know from the testimony that the officer who found the gun had to kneel down to find it, so this gun was not visible to Mr. Kelly Lomax from where he was sitting. Kelly Lomax didn't own or control the car where the gun was found. He never made any movements toward the gun. There were no fingerprints, and no one ever saw Mr. Kelly Lomax with the gun. There was evidence that was loosely connected another man in the car to the gun. A 911 caller had said that a man in a black puffy coat with a ring around it was holding a gun. One of the 4 men in the car had a blue jacket with stripes around it. Mr. Kelly Lomax didn't match that description. He was wearing a black hooded sweatshirt. Despite the lack of evidence against Mr. Kelly Lomax, the officers arrested him and charged him with possessing a gun. To support the arrest and the charges, the officers relied on 2 falsehoods. First, they claimed that the 911 caller had given a description of 2 armed men. The call is in the record. The relaying of the call from the dispatcher is in the record. He only identified 1 person, the man with a stripe around his jacket. There was no description of somebody who met what Kelly Lomax was wearing. The officers relied on that false description of a man who met Kelly Lomax's clothing to arrest him and to charge him. The officers also claimed that they viewed a surveillance video which showed 2 men with guns, one of whom matched Kelly Lomax.
Why should we conclude that these representations are lies and not just confusion?
This court shouldn't decide either one of those. It's a question for a jury. So I think that if the officers are able to convince a jury, somehow we misheard what the dispatcher told us and we thought that there was a description of 2 men, they can make that argument to a jury. We'll play what the dispatcher told them and say to the jury, don't draw that conclusion. The conclusion you should draw is that they only heard a description of 1 man. But those are credibility questions. They're questions about evidence that this court and the court below shouldn't decide on summary judgment.
There's a challenge, though, that we have here. Is there? Let me ask this with regard to the Gerstein hearing that happened quite soon afterwards. Is there any evidence in the record to suggest that the probable cause analysis changed after Kelly Lomax's Gerstein hearing?
Yes.
What is that?
The evidence about the surveillance video is nowhere to be found until the grand jury testimony, which came after the Gerstein hearing.
Right, there's more evidence that happens at the grand jury, but the Gerstein hearing, the probable cause standard itself didn't change. PC, what constitutes PC, remains the same, right?
I guess if the question is if there was probable cause at the time of the Gerstein hearing, would there also be probable cause later at the grand jury hearing?
Correct.
And I think the answer to that is yes, that we're not arguing that there was a diminution of evidence or something that took away from the other evidence.
So much of this appeal seems to turn on the quantum of evidence? Is it at or below probable cause or arguable probable cause? Obviously, it's far below conviction. This was a 15-minute trial.
That's right.
Where the directed verdict was granted almost immediately.
That's right, and I think that's because the Illinois cases, and one case from this court, so plainly say, if all the evidence you have is a gun under a seat, you have not shown the elements to.
And that's conviction, though.
Well,
Conviction and PC are different, right?
Yes, conviction and probable cause, there are different standards. But in every case, when this court considers probable cause, it says we look to the elements of the offense under Illinois law, and those elements are fleshed out in cases about conviction. And I'm sure there are some cases about conviction that turn very expressly on, was there enough evidence beyond a reasonable doubt? But the cases we're talking about never get to that. They apply rules about what the elements of the offense are, what Illinois law says is the definition of constructive possession.
The cases you showed us were cases, as you've said, about conviction, where an appellate court overturned the conviction because the state didn't put forth enough evidence that the defendant was aware there was a firearm under
Correct. No.
under his seat. Were you able to locate any cases where the indictment was thrown out for that reason? In other words, the procedural posture we have here, which is, probable cause to arrest and then probable cause to continue the prosecution.
So I'm not aware of cases where an indictment was thrown out based on that. I mean, I think the posture would be that the evidence that was lacking wouldn't come out just through the indictment. When the state, when the grand jury votes to charge, it's that the elements are not going to get tested until the trial. So the answer is no, we don't have cases about an indictment. But the cases that we do have from this court, as I said, consistently rely on elements of offenses as defined in cases from convictions. I mean, the example that we pointed to was Taylor versus Hughes, where this court went through 7 different cases that the Illinois courts decided on appeals from conviction. A similar thing in Young versus Chicago, where this court looked at Illinois cases decided after convictions. And
the difference with Taylor, though, is Taylor was hesitating to draw certain conclusions. Here, the relevant facts on which the officers could find probable cause are not disputed because there's not that challenge below. Illinois courts have developed a substantive law of constructive possession. It very well could be the case that the state's attorney's office said, do not dismiss cases involving guns. So the prosecutor's got to take the case to trial. Case gets to trial. 15 minutes later, the defendant is acquitted. The distinction with Taylor is here the relevant facts are undisputed, and there they weren't, right?
I think, well, no, I don't, that's not what the part of Taylor that I'm talking about is where the court carefully analyzed Illinois state cases and said how an Illinois court would treat these facts.
In Taylor, though, it wasn't clear whether the gun could be connected to Taylor.
I think that there were also disputed facts in Taylor that are somewhat different than ours. But I wouldn't say the facts are undisputed in this case. I think there are a lot of cases that acknowledge that probable cause is normally a jury question. And what the city, I think, is going to argue to you is this chain of inferences from what the officers did observe. And whether to believe that chain of inferences, whether to credit it as sufficient to show probable cause, should be a question for the jury.
Would you like to reserve the remainder of your time?
I do want to just, one more point I'll ask the court to consider. Oh, okay. Go ahead, Judge Lee.
If I could talk about qualified immunity in the context of the false arrest claim.
Okay.
So you point to Wise, and the parties talk about People versus Wise, and about its ruling about constructive possession. But Wise, at least in my reading, specifically states that it's not discussing the aggravated unlawful use of a weapon statute, right? And in fact, the dissent takes pains to say that what the majority is dealing with here, whatever it might be, it's not with the aggravated unlawful use of a weapon. And so my question is, given that, is under Illinois law, is the requirements of constructive possession in the context of guns and vehicles clearly enough established for qualified immunity to apply?
So I'm sorry, I don't have Wise in front of me. That's my recollection. Was it unlawful use of a weapon by a felon was the offense and not
Right.
aggravated?
No. Right. In Wise, it was possession by a felon, and here we're talking about aggravated unlawful use of a weapon.
Yeah, and I don't think there is any difference between the definition of possession. The Bailey case, which is the one that we rely on, where
No, I understand that, we trained in the law might not think there's a difference, but, where the Illinois Supreme Court says expressly, we're not dealing with this other statute, I'm not sure how we can expect a reasonable police officer to then think, oh, well, okay, well then what the rule in Wise does apply to the aggravated unlawful use of a weapon statute.
okay, then I don't, because I don't know that sentence in Wise that you're referring to. So if it's something that's important to the court, I can file a supplement on it, but I don't have an answer as I stand here.
Thank you.
Thanks.
I will be granting rebuttal time to you.
Thank you.
Thank you. We'll now move to the argument on behalf of the city, Mr. Enriquez.
May it please the court. One of the elements of the gun possession offense with which Kelly Lomax was charged is constructive possession of a gun. And he acknowledges that it is the only element he disputes in this case. That element requires a showing that the arrestee had both access to the gun and knowledge of the presence of the gun. Kelly Lomax does not dispute that the gun was found under the car's front passenger seat on which he was sitting, and he does not argue that he lacked access to the gun. His only challenge concerns his knowledge that whether the gun was there.
And that was the basis for the acquittal.
That was the basis for the acquittal. One of Kelly Lomax's claims in this case is the Fourth Amendment claim against the officers for false arrest. Based on the principles the Supreme Court set forth in its decision in the Manuel case, that claim necessarily seeks relief only for Kelly Lomax's detention that began at the moment of his arrest and ended the next day at his bail hearing or Gerstein hearing. So on that claim, the only issue is whether, at the moment of his arrest, the facts of record viewed from the standpoint of objectively reasonable police officers amount to probable cause that he knew the gun was under his seat. In that regard, the audio portion of the recording of the police officer's body-worn cameras is undisputed evidence that the dispatcher informed the officers that the 911 caller told her he saw at least 6 men standing outside a vehicle at the gas station, one of whom was wearing a dark jacket with stripes, and several of whom were pointing guns at the car.
But is there any evidence that the dispatcher told them that one of the people in possession of the gun had just a black jacket?
There is no evidence of that.
Right. So why isn't that a factual dispute? Because the officers say that they were told that one of the gun holders had just a simple black jacket and another had a black jacket with a white ring around the arm. And Mr. Kelly Lomax combs through the record and says, there's no evidence that the dispatcher told him that.
Well,
because isn't that important for the inference of knowledge that you would have the officers draw?
no, I think it's irrelevant. It's completely irrelevant.
So even if the officers were only told that there was one person with a gun and he had a black jacket with the white stripe on his sleeve, even if the hypothetical, that's only what the officers knew when they came onto the scene, what other facts would support the officers' reasonable belief that Mr. Kelly Lomax knew that the gun was there, other than just proximity?
Okay, well, it's undisputed from the video, the body-worn camera of the officers, that the dispatcher said that there were several men standing at the gas station, one of whom was wearing a dark jacket with stripes, and several of whom were pointing guns at the caller. And it is also undisputed that when the officers then arrived at the gas station, they encountered a vehicle containing 4 passengers, one of whom was a man wearing a dark jacket with stripes. And it is also undisputed that when the officers then searched the car, they found a gun under the car's front passenger seat on which Kelly Lomax had been sitting.
The other passengers in that car, they weren't wearing black jackets?
Yes, they were. All
so why didn't they arrest the other men instead, as opposed to Kelly Lomax? I mean, the only reason was that Kelly Lomax was sitting on the seat. And so I'm just trying to understand what other than proximity led the officers to arrest Kelly Lomax.
Well, I don't know why they didn't arrest the others. I have no idea. The only question in this case is whether there was probable cause to arrest Kelly Lomax, who would have, the officers would certainly have had reason to believe that Kelly Lomax would have known when, after the guns had been pointed at the caller and people returned to the car, he would have known that he would have seen the gun being placed under the seat at that moment. He was there for the entire event. The only importance of the man with the blue jacket is that it indicates that the car that the officers encountered was the right car. It had the man with the blue jacket in it. That's the only reason that the blue jacket is relevant. The black jackets aren't relevant at all because all 3 of the other people had them. What's relevant is that the officers found the gun under the seat of a person who would have seen, or unless he put it there himself, would have seen the gun being placed under the seat at the gas station after the people who got out of the car and were pointing guns got back into the car. They would have.
So there was some discussion in the briefing about whether or not it would be possible for the person sitting behind the passenger seat to slide the gun under the seat. And what is your response to that?
Well, I think the evidence is the officers said they couldn't have happened, but it doesn't matter at all.
Well, that's because of the green Propel bottle, right?
That's right. There were other obstacles under the seat. But whether or not other people might have put the gun under the seat or not, we're talking about probable cause. What officers have had probable cause to believe that whoever put the gun under the seat, Kelly Lomax would have seen the gun being placed under the seat when the other men got back into the car. Or at least the officers would have had reason to believe that he would have seen when the men who pointed the guns got back into the car, that they put that gun under the seat on which he was sitting. He had access to it. It's not clear that any of the others did have access to it. He had certainly had access to it. There was probable cause to believe not only that he had access to it, but that he knew it was there.
Could I ask you a question about the malicious prosecution claim? So, after the Girdstein hearing, there is a grand jury proceeding, and the officer testifies about what was on the videotape. And, the plaintiff raises all these issues about why that testimony kind of lacked credibility. And if in fact Officer Garduno did fabricate the evidence before the grand jury, wouldn't that tend to support the Fourth Amendment malicious prosecution claim? And then wouldn't whether or not Officer Guardano actually fabricated the evidence be a question of fact for the jury to decide?
No, I don't think so. I think that just like how the number of men involved in the case, whether there was 2 or 1 that the dispatcher told the police about, or whether the officers mistakenly thought that there were 2 rather than 1. It's also true that nothing about the video is relevant to this case. Nothing.
How is that possible? Because when I look at the grand jury testimony, it strikes me that the main evidence that the officer offered to the grand jury was what was on the video. And so I don't understand the position that the video and statements about the video have no relevance to the grand jury's determination. I mean, on page 4, the question prosecutor says, did your investigation reveal that depicted on the video surveillance system were subjects from the vehicle? And he says correct, and with pointing handguns in the direction of the Range Rover, and the officer says correct. I mean, that's basically the whole sum and substance of his testimony. And so if that was in fact fabricated, wouldn't that give rise to a potential malicious prosecution claim?
I don't think so. And the reason is that the important thing is that it doesn't change the fact that what the dispatcher told the officers was that there was a man with a stripe around a dark jacket with stripes at the location where he or other men were pointing guns, and that after they got to the scene, they identified the car with a man with a blue jacket, and then they searched the car and found a gun under the seat of one of the passengers. Nothing about the video changes that at all. The video, even if the video showed that no men had guns, even if that were completely false, it doesn't change the fact that when the officers arrived there, they had been told that there was a car there where a man with a blue jacket was standing next to a car. They found that car, they found the blue man, and then they found the gun under the seat of one of the passengers who had access to the car. There's reason to believe that all of the people, when they got back into the car, knew that there was a gun under the seat. That's why there was probable cause. And that's the only issue in the case, whether there's probable cause to believe that there was a gun, that he knew, that the person in that seat, Kelly Lomax, knew that the gun was under his seat. That's the only thing. I think the video is extraneous to that. It's a misleading aspect of the case. Now,
thank you, Mr. Enriquez. Thank you. Mr. Flaxman, we'll turn to you now for rebuttal argument. We'll give you 2 minutes.
Thank you. The reason that the video is important is because the probable cause inquiry at the stage where we're talking about at the grand jury is different. That if the court...
I thought you told me it was not.
Well,
you told me the PC stayed the same throughout.
Well, what I told you was that in this case, there was no dissipation of probable cause. So that we're not saying that there was some evidence that stopped being relevant. I didn't mean to say that the evidence was the same at both of them, because what we see is that at the grand jury, the evidence was presented and was used to continue that prosecution in a significantly different way than when we were talking about earlier, when we know that the prosecution was initiated and the arrest was made at the time of the arrest. So there are 2 different frames, and this court's cases recognize that the standard for probable cause is different at the time of arrest compared to looking at a malicious prosecution claim. There are other matters that were talked about, that most of them are disputes of fact, that counsel for the defense said that the showing that it's the same car matters, and the court should look at the difference between colors, the difference of where the pump it was, and those are questions the jury should consider. That's why we asked the court to reverse.
Thank you, Mr. Flaxman. Thank you, Mr. Enriquez. The case will be taken under advisement. That'll complete the court's arguments for this morning.